Good morning, everyone. My name is Dante Figueroa, and I am a legal analyst here at the Law Library of Congress in Washington, D.C. A warm welcome to all of our participants on both sides of the Atlantic. Today, we're delighted to present you this seminar on the legal framework of artificial intelligence in the European context with a focus on Italy, which will be presented by our guest speaker, my distinguished colleague, Roberto D'Orazio, who is a legal expert at the Italian Parliamentary Library, focusing on data protection, artificial intelligence, and new technologies at the European and Italian levels. We will aim at having a brief questions and answers time at the end of the presentation as possible. Roberto, welcome again, and thank you so much for being our guest speaker today. Can you please give us the general context of the regulatory framework for artificial intelligence at the European level so we can understand what is the Italian approach to the topic?
Yeah, I would like to thank the library for inviting me to take part in this webinar. It is a great honor, and I hope to be able to give useful insights into European and Italian legislation on the subject of artificial intelligence. As is well known, the key point of reference in our discussion is the regulation number 1689 of 2024, so-called AI Act in the European Union jargon. And as a preliminary remark, we have to recall that in the EU legal system of sources of law, the regulation is a self-executing act. That is to say, it doesn't require implementation by the legislator of member states, but it is directly enforceable, as such roughly comparable to federal laws and multi-level legal system. In this respect, the regulation as a source of law differs from the directive, which instead requires transposition to the legislation of member states and thus imposes, we used to say, an obligation of result rather than an obligation of means. Given this general clarification, we have to remember that the AI Act marks not only the end point, but also the starting point for further pieces of legislation may become necessary to be adopted by member states. Despite the general feature of this legal source, as we say, typically producing self-executing and uniform norms, the AI Act indeed leaves spaces for action by national lawmakers. This is an aspect already noted in connection with the General Data Protection Regulation, a law best known by its acronym GDPR, a law that, not by chance, has been compared in some of its parts to a directive dressed up as a regulation, or even a disguised directive, precisely because its implementation required a complementary legislation by member states. The same could be said concerning certain parts, certain segments of the AI Act, also because it is the result of an approval process in which the European Council worked to uphold national interests according an intergovernmental rather than a purely European approach. It is worth recalling that among the European institutions, the European Council is the political body defining the general priorities of the European Union and is composed by the heads of governments of member states. The AI regulation, although built in terms of its fundamental principle and structure, thus needs to be stabilized through national implementing measures in a number of areas. Some member states, such as Spain, had already passed laws that partially anticipated some of the contents of the regulation. Also in Italy, some bills were presented to Parliament before the European rules entered into force, aiming to introduce transparency measures for contents generated by AI systems, and more generally to establish the framework of a delegation from the Parliament to the government as for rulemaking on the subject. However, it is rather a narrow path, as no law can overlap with the regulation's provisions since they are directly applicable. This is forbidden by the European treaties, and therefore national lawmakers have competence only in matters where the regulation expressly allows it. They cannot duplicate European rules and domestic legislation, neither diminish or pursue their gold plating. At the level of European legislation, moreover, the regulation is part of a regulatory archipelago composed of other islands, the GDPR and the Digital Service Act, for example, with other expected to emerge, for example, the directive on civil liability for AI about to be approved some months ago, but currently withdrawn. The proximity of the regulation to other chapters of the EU digital law facilitates the task of those responsible for its interpretation, allowing them partly to rely on known definition and notions. On the other hand, this complicates the effort of interpretation due to some feature of novelty and divergence compared to other legislative texts, and calls for a general mapping enabling a whole view of the picture. Furthermore, mention must be made of the recent adoption by the Committee of Ministers of the Council of Europe of the Framework Convention on AI and Human Rights, Democracy and the Rule of Law, the first international treaty on the subject. Although the convention has a different and more limited scope of binding authority, it shares the purposes and to some extent the definitional framework of the European regulation, aiming to embed principle of human rights protection and democratic systems against the risk posed by AI within the international legal order. Against this backdrop, I would like to select 5 aspects on which to focus our attention. To paraphrase the title of a famous film, this is a case of 5 pieces, but not easy one, if we were to joke about the intricacy of these topics. The goal is to gather elements for an overall view, as Dante said, of the European law on this subject and to use them for some general consideration. The 5 key points relate to the general issue of regulation and legislative techniques, that is, whether and how AI should be regulated, a question that the European legislator has asked itself. Second, the main direction of the regulation. Then the matter of transparency, connecting to the protection against discrimination, the huge theme of personal data protection, and finally, certainly not least important, a brief but not necessarily self-evident reference to the implications of AI for democratic processes and the perspective of constitutionalism. Although all these aspects are challenging to address and do not exhaust the range of relevant topics worthy of discussion, they help in outlining the broader structure of European law. All that is relevant to understand the context in which the national developments on AI can find their place. In Italy, so far, these developments consist of a set of parliamentary bills mostly focused on specific subjects, and, as I noted before, is about to be approved by the Parliament a delegation of legislative authority to the government for the adoption of a comprehensive framework in this field. Regarding this second bill, this second proposal will be worth highlighting its main contents. The first point is the problem of the tech regulation. This is the first aspect, which arises not as a merely theoretical issue, but as a practical one. It concerns the scope, if not the very meaning of regulation once referred to AI. Indeed, many have questioned whether and how such a disruptive phenomenon can be the field of legal rules, rules capable to adhere to their subject matter, effective in their application, and yet not hindering technological, economic, and competitive developments. There is no doubt that we face a reality moving at dizzying speeds where everything seems condemned to instantaneous, sudden obsolescence. Law perhaps has never been that restful place, but the acceleration and depth of innovation marking our era, our times, are certainly unprecedented. Moreover, lawmakers have to deal with a widespread approach that relies on technology itself, the code, previously identified in software and today in algorithms. It would be a form of regulation clearly influenced by an economic and technological rationality, so much so that the digital world, animated by a sense of self-sufficiency, willingly entrusts its code with the role traditionally played by law. Therefore, if now it is primarily the algorithm, a product of private autonomy that establishes the rule and imposes certain values by embedding them in technology. It is easy to understand why it is generally considered the key to the power exercised today by digital platform. Even without indulging in visions that tend to fetishize algorithms, it seems undeniable that in such a scenario, the primary issue for regulatory tools is that they must be capable of regulating the regulators. Therefore, it is necessary for these tools to harness the normative power deployed by the so-called masters of algorithms. This power is known to stem from the central position they occupy within a network of markets offering countless goods, orchestrating interactions among operators and end users, the latter burdened by informational asymmetry, which exploits their lack of awareness about their rights regarding data and algorithmic criteria, as well as biases potentially exposing them to discrimination. This explains why transparency is among the main goals of EU legal regulation, pursued through measures aimed at enhancing the accountability of algorithm-based systems, capable of increasing users' and citizens' trust in the fairness of processes and decisions. Moreover, the law has had to become technology, reversing the trend that sought to marginalize legal rules. The law has pursued the integration of regulatory principle into the technological design of systems, applying the by design paradigm already adopted by the GDPR as a tool for ensuring effectiveness. This is a shift in perspective that cannot be underestimated as for its breadth and complexity, and can be better understood by focusing on a particular aspect of AI regulation. Sandboxes, for example. As it is well known, this is a normative tool already used at the UL level and within some national legal systems to address the most socio-economically relevant complexities of technology innovation. The AI Act referred to the so-called legal sandboxes or regulatory experimental spaces as defined by Article 57 of the Act. They are tools that are familiar to the American legal tradition and were used there before spreading to Europe. Their essential feature is the protected environment they create within which it's possible to carry out tests and checks relating to an innovative technological project subject to a temporary derogation or suspension of the relevant regulatory framework. In its typical configuration, the normative sandbox, on one hand, confines the effects of innovations, containing them precisely within a sandbox, like those in which children play to avoid getting hurt. On the other hand, through derogatory measures, it exempts such experimentation from the application of the existing rules. whose ordinary application could prevent it. This aims to let testing innovative phenomena in a real but circumscribed dimension assess their impact and establish the most appropriate rules when necessary. In this sense, the sandbox is essentially a balancing tool. Indeed, it serves as a place for confrontation and careful consideration of divergent or difficult to reconcile reasons, those of regulation and innovation, as well interests which may originate from the public or private sphere. In fact, it is widely recognized, even among those opposing these regulatory tools, arguing that they are innovation killing, that this tool is inherently involved with a balance of interests and should allow to reach a compromise between the interests protected by the legal system and those belonging to technological, economical innovation. Therefore, the importance of this normative tool, we could say metaphorically, a place of interaction between law and technology, has to be understood not only in its operational aspect. The sandboxes are experimental grounds, not only for technological innovation outputs, but also for regulatory production in the field, as well as the place of mediation, where came into play the reason of freedom of scientific research and economic activity on the one hand, and the safeguards required by the protection of fundamental rights and collective interest on the other hand. Such an approach conveys a conception of law inclined to effectiveness of the rules to be established. An expression of this can be seen in addition to the sandboxes in various forms of co-regulation included in the regulatory toolkit of the AI Act, codes of conduct, best practices, and the role played by independent authorities. It is interesting to remind that Spain has already passed legislation for the creation of sandbox in this field, un entorno controlado de pruebas in Spanish. There is also an aspect of no lesser importance to be taken into account when seeking to understand the sandbox model as it has been adopted in Europe. It is the precautionary principle, which is typically defined in relation to risks whose scope and intensity cannot be fully known in advance. This principle pervades the entire legal text and to some extent has an implicit relevance within it. The rules introduced by means of the AI Act encourage the dissemination of AI in view of the expected benefits, but stem from the awareness of an underlying risk, the loss of centrality of the anthropological element at the moment when cognitive functions that have been so far exclusive to human beings are attributed to technological systems. Indeed, and this is a theme that deeply concerns ethical philosophy, we are witnessing, as never before, a substantial delegation from humans to machine of faculties that are distinctive and defining of the human being. After recalling the issue behind the if and how to regulate, let us now focus on the regulation and its fundamental choices. The AI Act finds its first rationale in the market. It has been adopted to prevent fragmentation that could result from divergent national regulation, potentially jeopardizing the free movement of technological products and competition among European enterprise. However, if the EU concern is to facilitate developing and placing on the market of AI systems, it is equally essential that the change be accepted by individuals and by the business world. The regulation preamble explicitly refers to trust in AI systems and to the necessity that they develop within a regulatory framework consistent with the values of the Union and safeguarding the rights and fundamental freedoms recognized therein. It is made explicit that in the legal text that AI should be a human-centric technology. It should serve as a tool for people with the ultimate goal of enhancing human well-being. Underlying the regulation is also the European legislator ambition already pursued with the GDPR to export its own model and to influence how digital solutions are developed at the global level. In other words, to maintain what an American scholar, Andrew Bradford, called the Brussels effect, that is, to put through a regulatory power parameters spontaneously adopted outside the European Union and observed even by non-EU entities not subject to that power.
Roberto, thank you for this overview, which reflects the complexity of the topic, and you have explained to us. So, as I have a question, as artificial intelligence has rapidly become a battleground for competition between states, economic systems, and even between different visions of society, as you have proposed. In your view, is it possible to foresee geopolitical implications as well in relation with the spread of artificial intelligence in all the context that you have given us?
This is a very interesting and complex question. The topic would really deserve to be explored in a dedicated webinar. Let me mention once again a recent essay by Andrew Bradford that I mentioned before, a book. The title is, if I remember well, Digital Empires, the Global Battle to Regulate Technology. The three digital empires addressed in the book are the regulatory models that provide competing visions of the digital economy emerging from the United States, China, and the European Union. Based on the account of the author, the United States has a market-driven regulatory model, China a state-driven model, and the European Union approach is distinctly rights-driven. I find quite interesting that despite a prevailing wisdom that focuses on the China-United States axis of conflict, Bradford predicts that it will be the rights-driven EU model, not the historically prevailing US market-centered approach that likely will offer the leading alternative to China statism in the near term. Even with this striking prediction in mind, the most distinctive contribution of this book it is this synoptic model of geopolitical conflict. Although we have to avoid schematic reconstructions or drawing conclusions beyond our remit, we can confidently say that the European Union strategy is to present itself as a leader in the field of rulemaking and to ensure that the European model becomes a global standard and can be adopted within other parts of the world. The aim is not to compete with China and the United States only in terms of technological production, but rather as regards rulemaking. The main goal is affirming European digital sovereignty, which has an external aspect in being projected towards the other two global actors, as well as an internal effect on the European member states. On this side, the purpose is to establish a new model and avoiding fragmentation. This once again confirms the strategic design of European lawmakers that has been experienced with the GDPR, no? And now will be experienced with other pieces of European legislation, the Data Act, the Data Governance Act, and the recent regulation, very important, on the European health data space. This framework safeguards not only fundamental rights, but also European values, making it clear that it's not only legal rules that are at stake, but also the underlying culture of these rules. To greatly simplify the picture, and in order to answer your question, we can say that the model adopted in the USA is mainly a self-regulatory model based on an antitrust law. The Chinese model, on the other hand, appears to be a model based on state capitalism. Nevertheless, a Chinese feature is the fact that this country has been increasingly active in producing rules in the field of data protection, for example, with the Personal Information Protection Law of 2021, the Data Security Law entered into force the same year, and the Cybersecurity Law in force since 2017, if I'm not wrong. On the strategic side, the recent creation of the Shanghai Data Exchange also pursues the goal of creating a Shanghai model for the sale of data, with the ambition to resolve, to deal with the problems that currently hamper the circulation of data, and to present itself as a global reference model for eliminating risk associated with legal uncertainty. So, as we can see, laws and regulation not only mirror the traditions and even the mindset of the countries adopting them, but also act as a tool through which those countries compete on the global stage. Getting back to our previous point, we have to consider that faced with the complexity of such a challenge, the AI Act aims to provide a framework that is technological neutral, horizontal, and risk-based. Some legal definitions have to be taken in account, which cut across the current taxonomies of the AI, such as machine learning, natural language processing, cognitive systems, robotics, and so on. First of all, the AI systems, not AI as such, are defined regardless of the technical feature chosen during design and development. The category includes, according to the regulation, automated systems designed to operate with the varying levels of autonomy that may exhibit adaptability after deployment, in which, for explicit or implicit objective, infer from the input they receive how to generate output, such as predictions, content, recommendations, or decisions that might influence physical or virtual environments. At the core of their operation is the inferential capacity, which is in its various forms enable the system to learn, reason, or model. The horizontal approach, on the other hand, is expressed by rules which are applicable in all our areas of use and to all kinds of AI systems, but intended to be completed through sector-specific rules introduced by European Standardization Organization, dedicated to develop detailed solutions that translate legal requirements into specific technical prescription. The legislative choice that rests on technological neutrality and horizontality respond to the clear need to introduce a flexible, future-oriented regulatory framework suitable for the evolving nature and rapid development of AI-related technologies. Alongside these solutions, there is an additional and fundamental legislative choice that permeates the entire legal text and reflects the risk-based approach. To ensure a balance between the development of safe, reliable, and ethical AI, the regulation defines a pyramidal risk scale that categorized a system based on their level of risk: unacceptable, high, specific, and limited or minimal risk. For each of these categories, the AI Act uses a range of tools, which include prohibition, mandatory minimum requirements for design development of systems, and the imposition of transparency obligation of self-regulatory measures aimed at establishing rules proportionate to the interest to be protected in each case. In addition, and outside the risk scale, the AI Act also lays down specific rules for general purpose AI models, that is, those characterized by the ability to pursue various purposes, either for direct use or for integration to other AI systems. In this case, a specific risk categorization is provided, focused on the so-called systemic risks, that is, particular risk to public health, in the sense of healthcare, safety, fundamental rights, or society as a whole, and which can propagate along the many links in the AI value chain. Any practice, meaning certain uses or application domains of the systems, that pose risks considered unacceptable cannot be placed on the market, neither they can be used. In other words, the common denominator of this practice is their potential harm to the personal identity and dignity, since they aim to override individual awareness and the freedom and autonomy of their choices. The framework of the protection granted to individuals could be assumed as from the list of unacceptable practices that are outright prohibited, regardless of any risk assessment, due to their intrinsically harmful nature. The regulation lists the practices which are forbidden, albeit within certain contexts and subject to specific exception. These include the use of subliminal techniques, undue interference in the sphere of vulnerable persons, the assignment to an individual of a social score based on their characteristics of personal behaviors, the predictive profiling of individuals, and so on. This practice, the profiling and the prediction, raise crucial issues. The use of AI by public authorities for social scoring purposes, where individuals are scored based on behavior or personal characteristics, can lead to detrimental or unfavorable treatment that is unjustified or disproportionate. There are quite a number of examples of that, both in the United States and in Europe. While for the United States, we can recall the controversies surrounding the Loomis versus Wisconsin case and the use of predictive technologies in the field of justice administration. In Europe, we can mention the landmark Schufa case decided by the Court of Justice concerning the denial of financial services to individuals based on the score assigned to them and their right to understand in an intelligible manner the algorithm underlying the decision that affect them. Going on with the unacceptable practices, we find some of them sharing a common feature based on biometrics, the untargeted facial recognition from the Internet of Surveillance systems, the detection of a natural person's emotions, the biometric categorization, and so on. All these prohibitions, as I said before, are grounded in human dignity, autonomy, and privacy concern. The AI Act reflects the EU commitment to an anthropocentric and rights-respecting AI framework, one that protects individuals from manipulative or discriminatory technological practices. When speaking of AI high-risk system, we move closer to the third thematic profile of our interest, transparency, and its implication in relation to not be discriminated against. This is a principle safeguarded first and foremost by the provision of the regulation concerning AI system presenting specific risks of impersonation or deception, typically the deep fakes, which impose on providers and developers the fulfillment of obligation of information and transparency. The transparency requirements concern in particular those systems designed both to generate content and to interact with individuals that may pose a risk of harm to consumer or threaten democratic processes by spreading false or manipulated information on a large scale. In order to face such a risk, the regulation established that in the case of systems interacting directly with natural persons, the providers are required to design and develop the system in such a way that individuals are informed that they are interacting with an AI system, unless this is obvious to a reasonably well-informed, observant, and circumspect person, taking into account the circumstances and the context of use. The same goal is pursued also through the requirement of measures that make easily recognizable the artificial origin of audio content, images, videos, or text. Operators are in fact obliged to label the AI system output in a machine-readable format through an interoperable and effective technical solution that certify its artificial origin. There is a legislative proposal that have been submitted to Italian Parliament and is currently pending before Parliament, aimed at introducing implementing measures that require AI-generated content to be marked with signs recognizable to the user. So it's a problem with specific relevance. Aside from the variety of affected matters and application methods, the common postulate of the rules is clear. They aim to guarantee the existence of an ecosystem based on human-machine interaction and featured by the possible emergence of risks in terms of manipulation of consciousness and will. And they aim at disclosing this interaction so that the individual is able to recognize it, and with such awareness can make choices and adopt behaviors without undergoing interference and condition of any kind. Passing to the Shufa case that I mentioned before, very rapidly.
Roberto, do you mind if I intercalate a question on this?
Yeah, sure.
This is very, we're seeing that the Chufa case, as you explained, is one of the, seems to be the leading case, judicial case that been brought to the European Court that linked the topic of artificial intelligence and data protection law at that level. And could you explain a little bit more what this case was about, the fundamentals? Because at some point, all this legislation at the European level or at the domestic level, in this case of Italy, in this prospective legislation, these bills that are pending before the Italian Parliament that you're referred to and going to explain a little bit further. So at some point, all these provisions had to be tested in real cases, real people, real rights before real courts, right? They have to define. So and this is the challenge, right? Because this is a new legal framework. So if you could refer a little bit to the implications of the Chufa case, also, as if I'm sure you're familiar with the case, with the replica case, this emotional AI website that was directed to people who were considered vulnerable by an administrative court in Italy, as I understand, a few months ago, that ended up sanctioning or penalizing this company, establishing after a long investigation lasted for a couple of years, some sanctions. So we're seeing all this judicial action based on this artificial intelligence framework at both the European level and domestic level. Can you elaborate a little bit more on this, please?
Yeah. Very rapidly, the reasoning of the Court of Justice in the Shufa case was that Section 22 of the GDPR on automated decision system and profiling is applicable in the sense that in a credit score, in a decision based on credit scoring, on the credit scoring of an individual, where the three principal conditions laid down by the GDPR are fulfilled, these are there must be a decision. This decision must be based solely on automatic processing, including profiling, and it must produce legal effects concerning the interested person. Well, in this case, the Court of Justice stated that the Article 22 of the GDPR was fully applicable to the decision by which a bank refused a loan to a citizen on the basis of the report of a third party, the company Shufa, about his the expectation that he could meet his obligation. And the court clarified that the establishment of a credit score, even if it does not in itself constitute the final decision, must henceforth be regarded as an automatic individual decision within the meaning of the GDPR, as that score plays a decisive role in the final decision taken by a third party. So the Shufa decision highlights the importance of transparency in automatic decision-making processes, because under the GDPR, it is now established that the data subject, the interested person, have the right to know how algorithms are used to assess them and to understand the consequences of such assessment. In this regard, the Shufa decision also reaffirms the right of data subject under the GDPR, notably the right of access to information, to right to rectification information, and to right to object to the information collected on the interested person. But Shufa has not remained an isolated case, because the most recent significant ruling concerning the GDPR and transparency obligation in AI decision-making is another judgment of Court of Justice delivered last February, is the Dun and Bradstreet, Austria, and we have no enough time to explore all the implication of this decision. But the problem is the right to have an explanation about the algorithm, the logic, and the function of the algorithm, and the protection of the trade secrets. So the private interest to keep the secrecy of a commercial information, in this case, is balanced with the individual interest to know how a certain decision has been taken. So it's a very, very important point, and is a case law that is developing. So maybe that we will have soon other cases on this point. As we noted before, the scope of the obligation emerging for the Shufa case is the right to know the degree of relevance assumed by the algorithm in the decision-making process, and thus concern transparency about influence of the algorithm. Some commentators wrote that the Shufa case introduced a right to algorithmic sincerity, something that can be clearly communicated to the interested person. But I think that we have to perhaps I went too far in trying to reconstruct the legal and cultural framework in which European regulation took shape. However, I hope this was helpful in better understanding the context of the Italian legislative developments. Let's finally have a look at them, and let's consider above all the aforementioned proposal of delegation of the parliament to the government. It appears to be nearing completion, having been approved by both chamber of parliament, and now is facing the third reading by the Senate. The bill aims to codify principles for the research, experimentation, development, adoption, and application of AI systems and models in order to secure a fair, transparent, and responsible use of artificial intelligence in a human-centered and rights-respectful manner, with a view to seizing the opportunities it offers. Given this principle framework, substantially emulating the AI Act, the bill aims at laying down principles in the field of research, experimentation, development, adoption, and application of artificial intelligence system and models. And it promotes a fair, transparent, and responsible use of AI systems in a human-centered manner. The keywords taken from the bill show just how broad and varied the areas of intervention are. And they reveal how deeply AI is starting to shape every part of social life and how the state itself is organized. These are the key points, the main goals of the bill, although some scholars have pointed out the risk of an overlap with European regulation, which would not be permissible as the regulation takes precedence over Italian law, as we mentioned before. However, the bill is intended to address aspects that are specific to the national socioeconomic context, as well as areas not expressly covered by EU legislation or those that the regulation explicitly leaves to the lawmaking of individual member states. In particular, the AI Act aims to promote the development and adoption of safe and trustworthy AI system within the European single market. And the bill pushes the dual objective, promoting economic development and protecting individual freedoms and democratic order. While the widespread use of AI solutions brings numerous economic opportunities, it has also sparked a debate about the risk, as we told before. And the bill promotes the development of these systems, AI systems, in light with the relevant European regulation, and keep the human-centered approach by means of stating principle of transparency, accountability, fairness, and respect for fundamental rights. This principle aims to ensure a balance between the opportunities and the risk associated with the misuse, harmful application, or even the underuse of the new technologies.
Roberto, I'm sorry, would you mind if to illustrate us a little bit more about the different approaches, if any, that there exist in the Italian society toward, or which are reflected in the parliament toward artificial intelligence. In particular, you mentioned that at the geopolitical level, macro political geopolitical level. You mentioned the American approach, the Chinese approach, and somehow the European approach, which was very, very illustrative. But the question is, in the case specifically of Italy, do you see some forces, some approaches that are afraid of artificial intelligence, others that are pushing more and more in this on this road? I'm thinking as an example, not exclusive, but as just an example, the areas of health or employment. So do we see different approaches in Italian society that are somehow colliding, converging, and that will be put to the test by this new bill?
Well, the approach is perfectly in line with the European regulation, caution, trust, and risk evaluation, and is within this framework. As I told before, the AI Act states what kind of AI system can be put on the market, and what kind is excluded by any possibility to be put on the market. So this is the framework, the general framework. The Italian bill faces some peculiar aspect of the impact of the society. For example, you mentioned healthcare. It is a very important, is a very relevant aspect in the bill, and because the AI can produce many benefits from for the medical research, and medical innovation. And another point as for the impact of society that you mentioned, and it's very relevant, the decision of the minors' access to artificial intelligence technologies, particularly the children under the age of 14. For these children, the consent of the person exercising parental responsibility is required. Such consent must extend to the related processing of the child's personal data. So when a child uses ChatGPT, for example, on his smartphone, this is a problem of effectiveness, will be a problem of effectiveness of the law, because if aged under 14 years, it could not use ChatGPT. Minors aged 14 are granted the ability to give their own consent to the processing of personal data related to the use of artificial intelligence, but provided that the relevant information and communication are easily accessible and understandable. Now everybody is a common experience that the privacy policies, for example, of social network or other devices, are very, very complicated, and no one of us read them. So the problem of the genuinity of the consent, I think, is a topic that the bill faces, but I don't know how effective it will be. And I think that the industry should develop a system and devices to give importance to this legal requisite. As for the healthcare, the bill states that the AI system should help strengthen the healthcare system by supporting disease prevention, treatments, diagnosis, as well respecting people's rights, freedom, and personal data protection. Importantly, it's forbidden to use AI tools in a way that apply discriminatory criteria to determine access to healthcare services. This is a very important point, people also have the right to be informed when AI technologies are used in their care. So, and this is an application of the general principle that any individual has to to know that is dealing with an AI system and interface and not with a human.
Okay. Roberto, if I may, I have just one last question for you
Yeah.
before we open to several questions that we have in the Q&A. And the question is that in the document called Antica et Nova, Note on the Relationship Between Artificial Intelligence and Human Intelligence, the late Pope Francis mentioned that, and I quote, "The very use of the word intelligence in connection with IA can prove misleading and risks overlooking what is most precious in the human person. In light of this, AI should not be seen as an artificial form of human intelligence, but as a product of it." End of quote. So this is connecting with the sort of anthropocentric perspective you mentioned a little bit earlier concerning European and now Italian AI legislation. Can you please elaborate a little bit on this?
Well, ethical issues run throughout the entire reflection on AI and have been duly taken into account by legislator. The AI Act provides for the use of the codes of conduct, an instrument already tested in the field of data protection and that can contain ethical rules. This approach was already present in the Bletchley Declaration in 2023, signed by many countries, including United States, Italy, as well as the European Union, which gave a significant emphasis to ethical consideration. Moreover, in response to your observation, it is well known that the new Pope chose his name as a sign of continuity with Leo XIII, author in 1891 of the encyclical Rerum Novarum, which addressed the major social changes brought about the Industrial Revolution. Today, Leo XIV is carrying out his mission in a world where technology has no less impact on society and the human condition itself.
Okay. Roberto, we have just a few more minutes to go over questions, and I'm going to, unfortunately, arbitrarily select some of them. There's one very precise question from one of our participants who's asking whether the national regulations, in this case of Italy, could be more but not less protective than the European regulation. Is that correct?
Yes, it depends from the areas of regulation that have been eventually remitted by the European Union to the autonomy of national legislators. Taking the GDPR as an example, we know that in some areas, national legislation are stricter, some national legislation are stricter than others, according to their traditional and constitutional heritage or cultural traditions. So it could be that in some areas, for example, the minors, children age for having access to certain devices, some legislation could be stricter than other legislation, but I think they are very residual areas where the legislation has a margin of autonomy. The framework is designed by the European regulation.
Okay. Oh, thank you, Roberto. And I think we have, unfortunately, time for one last question, which is whether the issue of facial recognition is tackled by the EU regulations you have mentioned, or is included or will be included in the Italian bills that you mentioned.
No, no, it's an issue that is included in the AI Act. Is one of the prohibited or very limited use of AI systems. Is in the list of the practice that are very controversial of prohibited by the regulation.
Okay, Roberto, you have I think 10 seconds to to final remarks if you wish to uh, focus on something or say something about your presentation, and then we'll close.
Just two words on the importance of the AI regulation for democratic process in general. I think the public decision are a course of action that is based on a type of reasoning that's very different from the artificial intelligence reasonings. So we have to be very cautious in isolating the spread of this technology as a very useful tool, but it is not something that can replace the human decision in many areas, included the public decision, political decision in general. This is the point.
Okay, thank you, Roberto. I don't mean to interpret most of our participants, but I think your remarks have been tremendously useful to understand not only the European context and the Italian approach to AI, but also to mention topics that we on this other side of the Atlantic can relate to. All the topics that you mentioned, transparency, human rights, the innovation, are all topics that are totally present in our legislative debates in here in the U.S. Congress, and there's activity going on, and apparently will continue for a long time. So I just want to close to again thank you very much for sharing with us your expertise with us, and we look forward to an update in the near future. Thank you very much.
Thank you very much. Thank you for your attention, your kind attention. Thank you.
Thank you. Bye-bye.